Trump Legal Cases Daily Digest, December 26, 2023. Happy holiday season. Will Donald Trump disenfranchise the Supreme Court? This week's focus is on Trump's anticipated appeal to the Supreme Court following last week's ruling by the Colorado Supreme Court, barring him from the state's 2024 GOP presidential primary ballot. The ruling is based on a post-Civil War constitutional amendment preventing insurrectionists from holding office. Trump has expressed his intention to appeal, and the filing is expected to occur this week. It's important to note that Trump's status on the ballot, as the Republican frontrunner, doesn't impact his ongoing 4 criminal trials. The court schedules are anticipated to become more active in the new year, with oral arguments scheduled for January 9 in the D.C. Circuit Federal Appeals Court to decide whether Trump's federal election obstruction case should be dismissed due to presidential immunity. Stay tuned for updates on these legal developments. Colorado Supreme Court takes a stand, Trump unfit for office. In an article published by The Guardian on December 22, Margaret Sullivan believes that even if the Colorado justices don't prevail, they've reminded us that Trump has gone far beyond what's acceptable. The Colorado Supreme Court's recent ruling, barring Donald Trump from the state's primary ballot under the 14th Amendment, has ignited debates on whether political consequences should exist for a president who refuses a peaceful transfer of power and incites insurrection. Critics argue that the voters, not the courts, should decide such matters, overlooking the 2020 election outcome where voters chose Joe Biden, only to face Trump's refusal to accept the decision. Some question whether Trump's actions, without a legal conviction, truly qualify as insurrection, creating ambiguity around the constitutional disqualification criteria. Despite President Biden asserting that it's self-evident that Trump supported an insurrection, he acknowledges that the U.S. Supreme Court will make the ultimate decision. Ellie Mistel, a justice correspondent for The Nation, predicts the High Court will overturn Colorado's ruling 8-1, with Chief Justice John Roberts and Justice Elena Kagan writing the opinion, and only Justice Ketanji Brown Jackson dissenting. Constitutional scholars, like UCLA law professor Rick Hassan, emphasize the urgency for a swift Supreme Court decision, considering the potentially destabilizing impact on voters and the democratic process if eligibility determinations linger. The Colorado justice's assertion that Trump has exceeded acceptable limits for a presidential candidate reflects a victory for common sense and integrity, irrespective of the outcome. The ruling highlights the ongoing challenge of holding a candidate accountable for actions that transcend traditional norms and the delicate balance between legal interpretation and the imperative for a functional democracy. Police investigate threats against Colorado justices amid Trump ballot removal decision. Following the Colorado Supreme Court's decision to remove Donald Trump from the state's presidential primary ballot, police in Denver are actively investigating incidents targeting the justices involved in the ruling. Extra patrols have been deployed around their homes, and the FBI is collaborating with local law enforcement on the matter. While details of the investigations are undisclosed due to safety and privacy concerns, the Denver Police Department is committed to thoroughly examining reports of threats or harassment directed at the justices. This development comes in the aftermath of the 4-3 decision by Colorado's highest court, overturning a district court judge's ruling. The judge had acknowledged Trump's role in the January 6, 2021, Capitol attack but argued against barring him from the ballot, citing uncertainty about whether the U.S. Constitution's insurrection clause applied to the presidency. The Colorado Supreme Court disagreed, supporting the claims of 6 Colorado Republican and unaffiliated voters who contended that barring former Confederates from low-level offices but not the presidency would be nonsensical. The court has stayed its decision until January 4, pending a U.S. Supreme Court ruling, with a state deadline of January 5 for resolving the issue before the presidential primary ballots are printed. As the legal and political implications unfold, the investigation into threats against Colorado Supreme Court justices underscores the heightened tensions surrounding the decision to remove Trump from the state's ballot. It highlights the broader challenges of balancing democratic processes with security concerns. Trump's court conundrum threatens conservative jurisprudence. Donald Trump's attempt to appeal his disqualification from the Colorado primary ballot is not merely a challenge to his eligibility but a profound test for the conservative majority he helped shape on the U.S. Supreme Court. The Colorado Supreme Court's ruling, grounded in the 14th Amendment, strikes at the heart of conservative doctrines like originalism and textualism, which underpin the court's jurisprudence. Sidney Blumenthal notes that this decision poses an existential threat to the very methodologies Trump relied upon to appoint a reliable conservative majority on the Supreme Court. Conservative legal scholars, William Bode and Michael Stokes Paulson, assert that, based on strict originalist grounds, Trump is constitutionally barred from running for office due to his engagement in an insurrection on January 6, 2021. Sidney Blumenthal, columnist at The Guardian, believes that the conservative majority's conundrum lies in the fact that rejecting Trump's disqualification challenges their foundational doctrines. If the court were to deny certiorari or uphold Colorado's decision, Trump would face disqualification cases across states, potentially plunging the election into chaos. Blumenthal highlights that the Wall Street Journal, a reputed mouthpiece for Justices Clarence Thomas and Samuel Alito, vehemently criticizes the Colorado decision, reflecting the panic among Republican sponsors of the conservative court. The dilemma faced by the court underscores the clash between constitutional reasoning, historical context, and the desire to protect Trump's political future. Trump's legal defense appears to rely on challenging due process, arguing that the lack of a criminal conviction for insurrection hampers his disqualification. However, legal experts, including Mark Graber, emphasize that constitutional disqualifications are not contingent on criminality but serve as preventive measures to protect the democratic process. Blumenthal dissects potential escape hatches for the court, such as relying on a case like in re Griffin, and asserts that these attempts would echo the controversial and politically charged decision in Bush v. Gore. The unfolding legal drama brings to the forefront questions about the court's commitment to conservative principles when faced with a challenge from its creator, Donald Trump. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.